Assalamualaikum and good morning everyone. I am Azarina Izaham from Department of Anesthesiology and Intensive Care Fakulti of Medicine, University Kebangsaan Malaysia, and I will be the moderator of the webinar today. I would like to welcome you to our webinar from Personal and Professional Development, the specialist in the fast changing world, which is part of our Clinical Specialist Master Program. Our webinar today will consist of 4 lectures to be delivered by experts in their respective field from Medical Legal Society of Malaysia, beginning at 9 a.m. and it will end at 11 a.m. After that, it will be followed by a Q&A session between 11 a.m. to 12:30 noon. Please write your question at the Q&A box, not at the chat box, please. As a participant, you also required to write a report according to the respective department, and the link has been emailed to you. Okay, without further delay, I would like to introduce our first speaker. She will give a talk of discipline conduct by the MMC, and it will be delivered by Datin Anit Kaur of the Medical Legal Society of Malaysia. Datin Anit is a member of Lincoln Inn and was admitted to Bar of England and Wales in 1998, and as an advocate and solicitor of High Court of Malaya in 1999. She has been active in medical legal field from the beginning of her career, an accredited member of the panel of mediator of the Malaysian Mediation Centre since 2008. She's currently served on the Committee of Medical Legal Society of Malaysia. Now I would like to invite Datin Anit to deliver her lecture entitled Discipline Conduct by MMC. Please help me to welcome her.
Thank you, Prof. Thank you so much, UKM, for organizing this. Thank you so much, UKM, for getting the Medical Legal Society of Malaysia involved in discussing this very, very important topics. I'm going to go right into the slides that I have. Could you give me a moment while I just share them? I'm speaking about medical council proceedings. I understand from Prof that all of you here are now about to graduate from your master's program and surely to be minted as specialists very, very soon. You are all going to be working towards getting yourself onto the National Specialist Register, and you're all going to be working towards serving Malaysia as specialists in the future. So medical council proceedings are very important because the Malaysian Medical Council is the regulator that regulates medical practice in Malaysia. So why is it important? What are the functions of the MMC? The functions of the MMC are to register all medical practitioners, whether it's provisional and then you get your final registration and then even as a specialist. They then issue annual practicing certificates. That's where you apply to. They have a publication of list of registered medical practitioners with APCs, and then they also conduct disciplinary proceedings. That's what the functions of the MMC are. Now, what if there is a complaint? Now, MMC deals with ethical conduct. You have got your clinical practice and you've got ethical practice. So they're two different parts, they go hand in hand. It's like a zing and a zang. So what you are mostly going to be in practice now, but if there were complaints lodged against you, which are the provisions? There is the Medical Act and there's the Medical Regulations. Now the Medical Act was amended in 2012 and the Medical Regulations 1974 were amended and replaced in 2017. I'll show you what the difference is. So firstly, if you have complaints before 1st July of 2017, the applicable act would be the Medical Act and the regulations would be the 1974 regulations. With complaints that came after 1st July 2017, the applicable act is the Medical Amendment Act 2012, which has amended the same act substantially. Then you've got the medical regulations of 2017. That's what you have currently. I presume all of you are going to have complaints after 2017, and God forbid, never. But if you are, those are the provisions that are applicable. Now, earlier on, we were talking about serious misconduct or impaired misconduct. That was the test before the 2017. The current test under Section 29(2)(b) of the Medical Amendment Act 2012 is allegedly to have committed serious professional misconduct. So the word now that the MMC looks at on any complaint that comes to them is whether the medical practitioner has committed serious professional misconduct. What does that mean? Serious professional misconduct is actually defined within the Act itself, and this is the definition. It says it's failure to meet the minimum standards of professional medical practice as set out in the Code of Professional Conduct, guidelines, and directives issued by the Council. So what does this mean? All doctors need to know what are the Code of Professional Conduct that's by the MMC. They need to familiarize themselves with the guidelines that are applicable to their area of practice. They need to keep abreast with the directives issued by the Council. Where do you find this? You would ask. They're all on the MMC website. They're now accessible. It's not like previously that you need to get a book on it. They're not available online. They're available on the website. And these are just some of the codes that are there. It's not a conclusive list that I put, but these are just some of the codes. You've got a code of good medical practice. You've got a code of professional conduct. You've got a code for expert witnesses. You've got a code for credentialing. Now, that's what you're going to be interested in, a specialist credentialing. You've gone past this stage, but there's a guide book for house officers. There's confidentiality guidelines on what do you do when it comes to patient confidentiality. There's virtual consultation guidelines, which have become a trend now. That's something you're going to be interested in. There's standing orders, and there's medical practice guidelines. So this is what among the codes that you have. Then you've got another set. Now, this is a set of guidelines, ethical guidelines. These are, again, a few of the guidelines that they are. This is not an exhaustive list. You will see everything else on the website. You've got guidelines on HIV, you've got guidelines on brain death, you've got guidelines on medical genetics and genetic services, organ transplant, audio and visual recordings, consent, which is extremely important in every area, assisted reproduction for those of you who are doing ONG, medical records and reports, which are also extremely important in how you keep your records and reports, plagiarism, which is again very important with any research that you do. So these are all guidelines that are available. I will not go into the details, but this is just an overview. So if there is a potential breach of any of these codes and guidelines, that's when complaint can be lodged to the medical council. So these are examples of what the ethical breaches are. So again, we're trying this very fine line with clinical practice and ethical breaches, but be very clear, medical council's jurisdiction is to deal with serious professional misconduct. And a lot of times it is ethical breaches. So what are examples of that? A failure to have a chaperone during consultation or examination of a patient, especially a patient of the opposite sex. That is an example of what is an ethical breach. Fee splitting or kickback arrangements that there may be with medical device companies, with other doctors, referral fee. Though if they come to know there's evidence of that, that is something the medical council views very seriously, and they will take you on for it. Advertising for purposes of professional advantage. Now, these guidelines are not very clear. A lot of people are now on LinkedIn, on social media, but there's a fine line with advertising for purposes of professional advantage against others. Then there would be an ethical breach if you are in an emotional or sexual relationship with a patient. That's a no-no. You don't want to be caught doing that. Then, now this is extremely important, erasing, obliterating, tampering, or altering medical records to cover up an adverse event. Now, that is extremely important that you don't get into any of that because the medical council views it very, very seriously.
Datin,
Yes?
we are getting feedback from the students that the sound system is not so clear. Would you mind stopping your video for a while and continue? Perhaps that could improve the sound system. My apologies.
Sure. Let me do that. Is the sound system any better now?
Your voice seems to be breaking up. It's a bit hard for them to listen to.
Okay.
Sometimes your transmission can improve if you don't put your video on. Let's see whether that works.
Let me switch the Wi-Fi to the mobile to see if it's better. Is it any better now?
Maybe you can
hear
try.
you.
We can hear you quite well. Then maybe you can share your screen again and we try again.
Is it clearer now?
Yeah, it's a bit better.
Maybe I'll speak a bit slower, and if at any point, again, anyone could raise their hand. So just
Not really, Datin. It's still breaking up.
see. Can you hear Can you hear it now?
We can hear you, but when you are starting to present, it breaks up quite often.
Okay, let me try this one more time. What are the examples of ethical breaches?
Yeah, so there's a gap in the sentences.
I see.
Yeah. Could you try switching off your video for a while?
Sure.
Could you try switching off your video? Yes.
Now, is it better now?
Yes.
Okay, so switch off. Thank you. So what are the examples of some ethical breaches? Again, sorry about that. Failure to have a chaperone during the consultation or examination, especially with a patient and especially with one of the opposite sex. Now, the next ethical breach example is fee splitting or kickback arrangements, either with a medical device company or with another doctor paying a referral fee. And the medical council has evidence of that. They become quite concerned that this is happening because this is again against medical council guidelines. Advertising for the purpose of professional advantage. That's another example of ethical breaches. Emotional or sexual relationship with a patient, that's a no-no. If someone reports you, because then your impartiality and your professionalism is questioned, that would be serious professional misconduct. Erasing, obliterating, tempering, or altering medical records to cover up adverse events. Now, that the medical council takes very, very seriously because one of your Hippocratic oaths is to treat a patient and to treat them quite with absolute transparency and candor. So you have to be candid. So when you try to erase, obliterate, temper, or alter medical records to cover up something, they take that very, very seriously. So what happens when a complaint is filed? What do you do when you receive a complaint? So what happens is Regulation 38 kicks in, and this is the regulation of Medical Regulations 2017. Step one is every complaint that comes in is vetted by the PIC. The PIC can then summarily dismiss if it's anonymous. If they have insufficient particulars, they will throw it out of the complainant. Anyone can complain to the medical council, but they need to provide their particulars. Anonymous complaints and surat layangs are not entertained. If it's not a disciplinary matter, then they'll say, no, this is not for us, this is for CCAPs, this is for court. They can also decide that at the beginning. Or there is reason to doubt the truth. If there is no such doctor in its register, they can actually immediately summarily dismiss the complaint. Then that's the end of it. Nothing actually happens. Now, if they find anything from it, they then send the complaint to the doctor. MMC sends it to the doctor. Doctor is given 30 days to reply. I'd like to emphasize that when you get such a letter to reply, please contact your insurer or your lawyer. Please do not try to reply on your own if you have opportunity. Why? Because you may miss something that the MMC may want. It's very important to get legal advice at that point in time. And you put up your draft, speak to your insurer, professional indemnity insurer, speak to your lawyer and reply. Why I say this is we've seen a lot of letters where doctors tend to get emotional and write it in their letter that, oh, I did everything for the patient. I went out of my way. I spent the weekend here. Yet this is, I cannot believe the patient has done this. Now, I don't think the medical council looks at that very favorably. They want to see your reply to the complaint, and then why? Because they deliberate. They deliberate after that, after receiving the reply, and then they come up with an outcome, either no further action to be taken, or if they feel there's something that should be then referred and heard by the medical council, they appoint a disciplinary board to hear the inquiry. What happens is then you then have to appear before the disciplinary board, right? So who is the disciplinary board? Okay, the disciplinary board consists of the following members. At least 3 members who are on the council. The council now has elections. They have elected members. They have members from the universities. They have members that are appointed by the ministry. So out of that main council, 3 members of the disciplinary board are there, or 3 members of the main council sit on the disciplinary panel. You've got 3 fully registered medical practitioners of at least 10 years of good standing with the current annual practicing certificate. And you've got any other person other than paragraph A and B. You may have lay persons as well. So the quorum disciplinary board shall have at least 5 people. You will have they will have a secretariat representative, and you will have a legal advisor to the disciplinary board. So when you appear before them, you appear before at least 5 members. You appear before, sitting with them is a legal advisor and a member of the medical council secretariat. Now, at the end of the disciplinary hearing, where the disciplinary board hearing will hear the complainant. It will not hear the doctor. It's at the end of it, the disciplinary board will deliberate, and they've got 2 options. They either find no case to answer, and they say that's it. They are not taking this complaint any further, or they say there's sufficient evidence to support the complaint, and a charge is drafted. So that's step 1. What happens after that? Then you sit tight, you wait until the charge is received. When the charge is received, you have 2 options. One, to state your defense before the disciplinary board, and the second one, to state it before the full medical council. At this point in time, you need to decide which option you want to take. There are certain provisions that the disciplinary board may not allow witnesses, and a full medical council does. So depending on that, if you're bringing witnesses, you may want to go before the full medical council or the disciplinary board itself. Now that's your options. And at the end of that hearing, again, they deliberate, and there's 2 options. They either find no case to answer, or the doctor is guilty of the charge. Now that's the process flow. If you're found guilty, if a doctor, medical practitioner is found guilty, they'll invite a plea mitigation. This is generally done by the lawyer that represents you, your legal counsel. And after hearing such a plea, these are the options that the medical counsel can, or the punishment that the medical counsel can met out. Firstly, a reprimand, which is almost like a caution. It's a tap on the wrist just to say, shouldn't be done again. Secondly, they can order the practitioner's registration to be subject to conditions. What are these conditions? If they find their anger management issues, they can say this is subject to the medical practitioner going for a therapy, doing certain number of hours of community service. It's up to the medical counsel how they decide what they think would be right to improve the practitioner's conduct on how to practice to avoid such a situation again. It can be rehabilitative, right? Now, the third option is suspension for a period thought fit but not exceeding 2 years. Fourthly, if it's that severe, they can order the name to be struck off the register. That means you have got no longer a license to practice. Fifthly, there is a fine. These are all coded in section 31 and 30, subsection 1 and subsection 2 of the Medical Act. So these are what punishments that can be meted out. What happens after that? You've got a right to appeal. Medical practitioners have a right to appeal. So any person aggrieved by an order made against him may appeal to the High Court within 1 month of the service of the order. So you can appeal this to the High Court. The High Court then hears the whole thing again based on the verbatim medical transcripts of the medical inquiry. It's transcribed verbatim. That's put before the High Court. We try to show serious error as legal practitioners before the court. And after hearing that, the High Court can either affirm the decision, vary it, or set it aside. This decision, it then has one more chance. You can still appeal this to the Court of Appeal, and that's the Court of Final Appeal. This is basically the flow of what happens when there is a medical counsel complaint and disciplinary proceedings against a medical practitioner. So I've given you a very theoretical background. I'd just like to very quickly go through 2 case studies so that you can see the kind of things that go before the medical counsel. Firstly, this was a complaint by a mother, a young mother, and I'm quoting this in inverted commas, about doctor negligence mistake on full pediatric examination of my newborn. So this baby was delivered by cesarean section 9th October. The pediatrician, Dr. YCH, examined and discharged the baby on the 12th of October. The review was for jaundice. Sorry, there's a typo there. The baby had some jaundice and a review was fixed for 15th of October. The baby's eyes were barely open, but the doctor didn't say much about it. But when the mother went back to the doctor, YCH, on the 15th of October, they asked, what's wrong with my baby's eyes? They're barely open. Then Dr. YCH examined and said, actually, it's not well developed, and referred to Dr. MSG, an ophthalmologist, for eye screening. The diagnosis of Dr. MSG was bilateral corneal opacity, TRO, congenital infection. I'm told this is 1 in 100,000, and this baby had it. So the complaint was, the mother was disappointed with Dr. YCH, said should have detected it early. And what she said before the medical counsel was, I paid examination fee, I expect an accurate diagnosis. This was her complaint. So what was the medical counsel's finding? After hearing the entire complaint, the doctor explained that he noticed something wrong, but he wanted to give the benefit of the doubt, and he saw that the mother herself was not in a good mental state, and a potential postpartum depression may have set in if he had said it too early, so he waited for the right opportune time. But the medical counsel's finding was the doctor was guilty for delayed and inadequate examination of infant post-delivery and inadequate explanation despite concerns raised by the parents. So that was the finding. So if you make a clinical decision to say, I'm not going to tell the patient yet, make sure it's recorded somewhere and make sure you get someone else to say it. Or if you cannot say it to the mother, the morale is of this story is to say it to the father, the parent, the grandparent, somebody, so that you are not then said to have not adequately explained, not said it on time, not done it immediately. So that, and the patient was and the doctor was reprimanded. That was case study 1. So case study 2, very quickly, I know my time's running out, is the patient was diabetic. He was on regular treatment for 20 years. On 21st April, he developed symptoms of hunger at 9 p.m. Blood sugar was 3.4. That was the reading of the blood sugar. The symptoms resolved after eating some food. The next day, he had the following symptoms: lightheaded, general weakness, awareness of heartbeat, sweating, feeling faint. He contacted his family doctor, also his uncle, and he was advised to go to the GP clinic immediately. So the uncle actually conducted the examination, and he found that he was had low blood pressure, pulse was 70 to 80 beats, blood sugar was 10.6, the heart was normal. This was what the GP found, but not happy. He referred him to an endocrine specialist the same evening. Patient saw the endocrine specialist. The allegation was, after hearing out my story and without explaining me in a manner whatsoever, he explained away my symptoms due to hypoglycemia, billed 235 and said it was due to hypo. So that is what the patient was unhappy about. Sadly, this case, which was more a clinical and negligence issue, if at all, went to the medical council. Why? Because the next morning, Dr. D asked the patient to come back to the clinic because he was his uncle, very concerned about this patient. He went back at 12 noon. He referred him to the emergency unit at University Malaya Medical Center. And the ED doctor, according to the complainant, did a thorough checkup, confirmed that I had suffered a major heart attack. Again, this is major heart attack told by the ED doctor. And because of this, the patient got very alarmed. And after doing angioplasty, he was discharged on the 27th of April. So he was hospitalized for 5 days. This is what caused the complaint. So the complaint was grossly erroneous, that symptoms due to hypoglycemia without examination and the method of arriving at the diagnosis was slipshod and unprofessional. This is what the patient complained about. Now, what the doctor was heard before the PIC, and the PIC decided there was enough evidence to substantiate the charge, to substantiate the complaint, and then preferred a charge. The charge was this: fail to provide and maintain a good standard of medical care by not providing sufficiently thorough professional attention, examination, and where necessary, diagnostic investigation. You have neglected or disregarded your professional responsibility contrary to Section 1, Subsection 1, Subsection B of the Code of Professional Conduct. Now, this is an interesting case because I thought, when I first saw it, I thought it was clearly a case, if at all, for negligence, but they thought fit to charge it. But fortunately, at the end of it, the doctor's defense was this: he saw the patient that day for 45 minutes. The patient walked in coherent, not breathless, not pale, no complaint of chest pain, neck pain, or left arm pain. He took temperature, he took BP, he took pulse. So remember, there was a complaint of not adequately examining. But here, there was temperature taken, BP taken, pulse taken. He gave an appointment of 1 week after adjusting the medication. Remember, he was an endocrinologist. The claim was of a diabetic of 20 years. So at the end of it, the medical council found no case to answer. This is what was the outcome. But I just wanted to show you, this is not clear examples of what I said earlier of not having a chaperone, not plagiarizing, something very fee-splitting. These are cases of clinical practice that you may come across, but may still land up in the medical council as disciplinary proceedings. So thank you very much. Thank you for listening, and I apologize again for the sound. Over to you, Prof.
Thank you very much, Datin, for a very good information during the talk. And I think there is some technical glitch, but I think because of your internet connection, then it's okay. All right, thank you again.